Hello, my name's Declan O'Dempsey. I'm from Cloisters Chambers, and I'd like to talk to you about the duties of directors in law. Now, I'm going to start where we are at the moment, which is with the 2006 Companies Act, and in particular Chapter 2, Part 10. But in fact what this does is to codify certain common law duties and equitable duties of directors. It's possible to summarise the general duties of directors as being to act within their powers, to promote the success of the company, to exercise independent judgment, to exercise reasonable care, skill and diligence, to avoid conflicts of interest, and not to accept benefits from third parties. They should declare an interest in a proposed transaction or arrangement. You can see essentially those are duties of probity for the company director. The duties, however, correspond closely to the common law duties or the equitable duties which directors have had. The scheme behind the Act was to codify, as it were, taking a snapshot of where the common law or equitable duties were at that time. The new statutory duties must be interpreted and applied in the same way as the common law and equitable principles, and regard must be had to those principles and rules in applying them. Section 170, subsection 4 of the Companies Act spells that out. The other interesting thing, I said that the codification was more like a snapshot, is that the codification is not exhaustive. Directors are still going to have duties under common law and equity. So it's important then to appreciate the pre-existing law as well as this code. I'd like first of all to turn to the different types of director. Essentially what's important is that all of the duties I'm going to be talking about apply to somebody if they're a director. But you can become a director or be a director in several different ways. There are some that we're very familiar with. For example, the executive director. That'll be somebody who carries out functions in the company, normally an employee in some form of that company. Then there's the non-executive director. Not an employee of the company, doesn't hold an executive office, but the director devotes part of their time to the affairs of the company. They're a kind of independent advisor or supervisor. But there are other forms of director which are perhaps less familiar. There's what's known as the de jure director. So that just means a director in law. All this means is that the person has been validly appointed as a director, and it's used in contradistinction to a de facto director. Now this is a person who acts as if he or she is a director and is treated as such by the board, but who in fact has not been validly appointed. Nevertheless, that sort of person will act openly as if they're a director. Not so the next. There's the concept of the shadow director. Now this is any person in accordance with whose directions or instructions the directors of the company are accustomed to act. You can find this definition in section 741(2) of the Companies Act 1985, and you can find it again in section 2511 of the Companies Act 2006. Now, the shadow director is possibly the more difficult one to detect. This is not somebody who's acting openly as a director, but it's somebody with a crucial amount of influence over the actual board of directors. It's not necessary for the entire board to be accustomed to act at the direction of the person who is alleged to be a shadow director. And it's possible that a person will be a shadow director if the governing majority of the board is accustomed to act in accordance with their directions. Moreover, the board must actually act in accordance with those directions. So there has to be action in accordance with directions, as well as the board being accustomed to act in accordance with those directions. The board therefore must actually do something in conformity with the shadow director's instructions, so that the simple fact that the alleged shadow director gave instructions doesn't render that person a shadow director. And you can have a look at the ultra-frame case for this. Now, I said that there were a whole range of common law and fiduciary duties surrounding directors, and this case law has developed over many years, up to October 2007, where it had this snapshot taken of it, as it were. There are, broadly speaking, fiduciary duties, good faith, loyalty, and common law duties, which essentially are duties of exercising skill and care. The company is owed by the directors, in addition, a duty of confidence in equity. So in other words, the equitable courts would always enforce that duty as a matter of the person's conscience when they're a director. So the situation as at 2007 was that the case law had established that it didn't matter whether you were an executive director or a non-executive director. There's no principled distinction between the two states in terms of the duties owed to the company. You can have a look at the Dorchester case for that. If you are a de facto director, well, you will owe duties, the director's duties, to the company in relation to which you perform those duties. And there was a case called Canadian Land Reclaiming and Colonising Company, which gives you that. It's also important that the de facto director may not have that status for a sustained period of time. It may be that simply in relation to one function, a person is a de facto director. A shadow director doesn't necessarily owe the full range of fiduciary duties. Which duties are owed will depend on the position of the person and their functions. It's important to remember that the duties owed by a director, the fiduciary duties, are owed to the company. It follows, therefore, that only the company can enforce them, and directors don't, by virtue of that fact, owe such duties to the shareholders or creditors. Sometimes shareholders will be able to bring what's called a derivative action on the company's behalf. The fiduciary duties which directors owe don't preclude, in special circumstances, the existence of additional duties which they owe to the shareholders. Now, under these duties, individual shareholders might be able to bring a direct action against the director as distinct from a derivative one. The issue, however, for our purposes, is that the duties didn't arise from the relationship between the directors and the company. Where those direct relationships have been established, they've been dependent on the special facts of the case, so that a relationship will have been indicated as existing between the directors and the shareholders. For example, where the director undertakes or is treated as having assumed responsibility to act on behalf or for the benefit of the shareholder, then such duties would exist. So an example of that would be where the director makes a direct approach and deals with shareholders in relation to a specific transaction. And if the director holds themselves out as agents for the shareholders in connection with the acquisition or disposal of shares. Suppose the director made material representations to shareholders or failed to make material disclosures of insider information in the context of negotiations for a takeover. Well then, those would be the sorts of cases where a direct duty would arise. And similarly, where directors supplied to shareholders specific information and advice on which they relied. Lord Justice Mummery dealt with this in the Peskin case.